Hello, my name is Nicole Bazzi, and I am a member at Burns White. I primarily practice in the transportation and occupational safety and health groups. Today, I'm going to briefly discuss OSHA compliance issues in the age of COVID-19. As of early August, there were nearly 30,000 complaints regarding COVID-19 filed under federal and state OSHA program. And as a result of the drastic increased OSHA reporting, on April 8th, OSHA issued a press release reminding employers that it is illegal to retaliate against employees reporting unsafe or unhealthy work conditions during the coronavirus pandemic. One thing employers should be aware of with respect to retaliation during this pandemic is that the enforcement of an attendance policy might constitute unlawful retaliation under OSHA's anti-retaliation provisions. This could include offering bonuses or other perks to employees who come to work. Employers need to consider the potential for citation where an employee has a reasonable belief that he or she may be subjected to the risk of contracting COVID-19 infection by working. In addition to retaliation claims, employers need to be aware of other potential citations relating to COVID-19. Since late July, OSHA has cited over 62 different employers with coronavirus-related violations, and proposed penalties now total near $1 million. Some of the employers that were issued citations are large companies such as Amazon, Target, Tesla, and Tyson. OSHA has not issued a coronavirus-specific regulation or standard, and they've actually received a lot of criticism in the media for failing to do so. However, OSHA has consistently taken the position that it has existing standards that serve as the basis for COVID-19 enforcement, such as the respiratory protection standard, the personal protective equipment standard, sanitation standard, hazard communication standard, as well as the general duty clause. The general duty clause can almost always serve as a basis for a citation. This catch-all provision requires employers to furnish a place of employment which is free from recognized hazards that are causing or likely to cause death or serious physical harm to employees, and to comply with all standards, rules, regulations, and orders promulgated under the Occupational Health and Safety Act. Obviously, COVID-19 is one such hazard. To date, with respect to COVID-19, OSHA has issued citations to employers for failing to comply with recording and reporting requirements, personal protective equipment standards, or respiratory standards, in violation of the general duty clause. However, it is important for employers to keep in mind that nothing prevents OSHA from issuing citations for any violation observed, even if those violations are unrelated to COVID-19. So if an employee makes a COVID-19 related complaint and OSHA comes out to do an inspection and doesn't find any merit to that complaint, they can still issue a citation for anything else they see that is in violation of the standard and regulations. One situation involving COVID-19 related citations involves 3 nursing homes in Ohio. In mid-July, OSHA cited the facilities for violating the respiratory protection standards. The healthcare company that owned the homes reported that 7 of their employees were hospitalized because of COVID-19. This prompted OSHA to conduct an inspection of the 3 facilities. According to OSHA, the facilities failed to develop a comprehensive respiratory protection program and did not evaluate the employees' ability to use respirators in the workplace. OSHA also said the company allowed N95 respirators to be used for up to 7 days and didn't conduct initial fit testing. So here, the company was trying to do the right thing and provided its employees with N95 respirators. However, because it did not implement effective respiratory protection programs, all 3 facilities were cited, and OSHA proposed $40,482 in penalty for these violations. OSHA issued a citation to Smithfield Foods, which is actually the world's largest pork processor. The citation was for failure to protect workers during an April COVID-19 outbreak at a South Dakota plant. 4 employees died and 1,300 employees contracted COVID-19. The OSHA citation stated that Smithfield employees worked close together and were exposed to the virus. OSHA proposed fining Smithfield $13,494, which is the maximum amount allowed under the law, under the general duty clause, for failing to provide a workplace free from recognized hazards that can cause death or serious harm. OSHA stated that employers must quickly implement appropriate measures to protect their workers' safety and health. They must meet their obligation and take the necessary actions to prevent the spread of coronavirus at their work site. Now, as we've discussed, OSHA does not have has not issued a specific COVID-19 regulation. However, in March, they did issue guidance on preparing workplaces for COVID-19. This document contains several recommendations for employers, such as developing infectious disease preparedness and response plans, putting infection prevention measures into place, such as social distancing, physical barriers, face shields, implementing policies for prompt identification and isolation of sick individuals, and ensuring employees have an open line of communication with their employers so that they are comfortable reporting concerns they have to the employer. OSHA guidance also advises that employers provide safety and health information through training, visual aids, and other means to communicate important safety warnings. While this guidance is advisory in nature, it does offer evidence of a duty of care that employers owe employees. Failure to comply with OSHA's guidance may put you at an increased risk of citation under the General Duty Clause for failure to maintain a safe and healthy workplace. Further, employers need to be cognizant of state and local regulations as well. For example, Virginia has enacted workplace safety and health standards that closely track the OSHA guidance document. Additionally, the city of Philadelphia enacted legislation requiring employers to comply with all aspects of public health orders. So going forward, we know that COVID-19 is a stated priority of OSHA. OSHA will continue to perform inspections and respond to employee complaints, which will result in more citations. It's important for employers to review their OSHA-required health and safety programs and their program documents to make sure that they are current with OSHA regulatory requirements. Employers also need to keep in mind that the guidance provided by OSHA can be used as evidence of a standard of care.